Important points on Anti-Money Laundering Act or the Republic Act 9160. So, the covered transactions in AMLA, okay? Covered transaction is a transaction in cash or other equivalent monetary instrument involving a total in excess of 500,000 pesos within a one banking day. While a covered institution, it may be referred to as the bank, the non-banks, quasi-banks, trust entities, and other institutions and their subsidiaries and affiliates supervised or regulated by BSP. It may also be an insurance company or any insurance or institutions supervised by the Insurance Commission. It may likewise be any security dealers, brokers, investment houses, and other similar entities managing securities or rendering services as investment agent, advisor, or consultant. It can also be a mutual fund, a closed-end investment company, a foreign exchange corporation, okay, and other entities administer or otherwise dealing in currency, commodities, or financial derivatives based thereon, valuable objects, cash substitutes, and other similar monetary instruments or property supervised or regulated by the Securities and Exchange Commission. So these covered institutions have some obligations to maintain in order to be covered by the AMLA. One is the customer identification. In here, the covered institution shall establish and record the true identity of its client based on official documents. It must likewise maintain a system, okay, of verifying the true identity of their clients. Another one is to record or to keep the records of their clients or the record keeping. All records of all the transactions of covered institutions shall be maintained and safely stored for 5 years as provided by the Anti-Money Laundering Act. Okay, with respect to closed accounts, the records on customer identification, account files, and business correspondence shall be preserved and safely stored for at least 5 years from the date when they were closed. Okay. Last obligation is that they have the obligation to report covered and suspicious transaction. Covered institution shall report to the AMLC all covered transaction and suspicious transaction within 5 working days from occurrence thereof, unless the supervising authority prescribes a longer period not exceeding 10 working days. With regards to anonymous accounts or accounts under fictitious names and all other similar accounts, it shall be absolutely prohibited. Okay? Peso and foreign currency non-checking number accounts shall be allowed. So what are those suspicious transactions? Suspicious transactions are transactions with covered institution regardless of the amount involved, okay, kahit hindi sobra ng 500,000, where any of the following circumstances exist. So there are 7 listed transactions. 1, when there is no underlying legal or trade obligation, purpose, or economic justification. Number 2, when the client is not properly identified. Remember, one of the obligations of the banks is to verify to establish and to record true identity of its clients. Number 3, the amount involved is not commensurate with the business or financial capacity of the client. Number 4, it may be perceived that the client's transaction is structured in order to avoid being the subject of reporting requirements under the AMLA. Number 5, any circumstance relating to the transaction which is observed to deviate from the profile of the client and or the client's past transaction with the covered institution. Number 6, the transaction is in any way related to unlawful activity or offense under AMLA that is about to be, is being, or has been committed. And lastly, any transaction that is similar or analogous to the foregoing. Some of the unlawful activities referred to under AMLA are the following. Number 1, kidnapping for ransom, violation for the Dangerous Drugs Act, the violation on anti-graft and corrupt practices, the plunder, robbery and extortion, wetting and mashaw, piracy, qualified theft, swindling, smuggling, violation of the E-Commerce Act, hijacking, and so on. Okay? Question: when is money laundering committed? Okay? Money laundering is a crime, okay, whereby the proceeds of an unlawful activity are transacted, thereby making them appear to have been originated from a legitimate source. Okay? Committed by whom? Okay, 1. Any person knowing that any monetary instrument or property represents, involves, or relates to the proceeds of any unlawful activity, transacts, or attempts to transact said monetary or property. So any person who has the personal knowledge to the unlawful activity, and that activity represents or may only be involved or only related to the said proceed, okay, that you are already committing money laundering. Another one, any person who knowing that any money instrument or property involves the proceeds of any unlawful activity, performs or fails to perform any act as a result of which he facilitates the offense or money laundering. And lastly, any person knowing that the monetary instrument or property is required under this act to be disclosed and filed with the AMLC fails to do so. So there are 3 ways to commit the money laundering. Okay, how is freezing of monetary instrument or property done? The Court of Appeals may issue a freeze order which shall be effective immediately for a period of 20 days unless extended by the court. In the case of Republic versus Cabrini 489 Scrap 644, the Supreme Court said that by the amendment of RA 9194 of RA 9160, it erased any doubt on the jurisdiction of the Court of Appeals over the extension of freeze order. As the law now stands, it is solely the Court of Appeals which has the authority to issue a freeze order as well as to extend its effectivity. It also has now the exclusive jurisdiction to extend existing freeze order previously issued by the AMLC vis-a-vis accounts and deposits related to the anti-money laundering activity. Example: Rudy is jobless but is reputed to be a wetting operator. He has never been charged or convicted of any crime. He maintains several bank accounts and has purchased 5 houses and lots for his children from Luansing Realty Incorporation since he does not have any visible job. The company reported his purchases to AMLC. Thereafter, the AMLC charged him the violation of anti-money laundering law. Upon request of AMLC, the bank disclosed to it the bank accounts of Rudy amounting to 100 million. Subsequently, he was charged in court for violation of anti-money laundering law. Questions. Number 1. Can Rudy move to dismiss the case on the ground that he has no criminal record? Question. Answer, no. Rudy may not move to dismiss the fact that he has no criminal record. Okay? And under the anti-money laundering law, Rudy would be guilty of a money laundering crime committed when the proceeds of an unlawful activity like wetting operation are made to appear as having originated from legitimate sources. The money laundering crime is separate and distinct from the unlawful activity of being a wetting operator and requires no previous conviction for unlawful activity. Number 2. To raise funds for his defense, Rudy sold the houses and lots to a friend. Can Luansing Realty Incorporation be compelled to transfer to the buyer ownership of the houses and lots? The answer there is no. Okay, Luansing Realty is not a covered institution. Being a real estate company, it is not one of those mentioned under the AMLC. Hence, Luansing Realty has no justification under the said law to refuse to transfer the buyer ownership of the house and lot. In that case, Luansing Realty, has no justification under the said law to not transfer the ownership from the seller to the buyer. It cannot refuse to transfer the ownership. So the answer there is yes pala. Sorry. You can compel the Luansing Realty. In disclosing Rudy's bank account to AMLC, did the bank violate any law? The answer there is no. The bank did not violate any law. The bank is a covered institution under AML law. As such, it is obliged to report to the AMLC covered and suspicious transactions without violating any law. This is one of the exceptions of the Secrecy of Bank Deposit Act. Last question. Supposing that the titles of the houses and lots are in possession of Luansing Realty Incorporation, is it under obligation to deliver the titles to Rudy? The answer there is yes. It has an obligation to deliver titles to Rudy. Not being a covered institution, Luansing Realty may not avoid, it cannot refuse its obligation by invoking the AML